Good day, everyone. We are Group 4, and we're gonna tackle chapters 2 and 3 of Law of Sales. Let us start with chapter 2, which covers the topic of capacity to buy and sell. According to Article 1489, all persons who are authorized in this code to obligate themselves may enter into a contract of sale, saving the modifications contained in the following articles. Where necessaries are sold and delivered to a minor or other person without capacity to act, he must pay a reasonable price thereof. Necessaries are those referred in Article 290. The Article 1489 just states that anyone who is legally allowed to make binding agreements can enter into a contract of sales. However, there are some exemptions to this, such as if essential items like food, clothing, or medicines are sold and given to a minor or someone who legally can't make contracts. They still have to pay for fair price for them. For example, a minor goes to a pharmacy and buys medicine for a fever. If later the minor claims that he is not responsible to pay for the medicine, the law still holds him responsible because the medicine was a necessary. There are two types of incapacity, namely absolute and relative. Such incapacity is absolute in the case of person who cannot bind themselves, and relative where it exists only with reference to certain persons or certain class of property. In absolute incapacity, a person cannot legally make a contract at all. For example, a person who is declared insane or is mentally incapacitated cannot bind themselves in any contract. In relative incapacity, on the other hand, a person can make contracts, but not in a certain situation or with certain people. For example, a spouse may not be allowed to sell property to their partner without legal permission. They have relative incapacity in that context only. There are exemptions to incapacity. Contracts entered into by a minor and any other incapacitated person, for example, insane or demented person, deaf mutes who do not know how to write, are voidable. However, where necessaries are sold and delivered to him without the intervention of the parent or guardian, he must pay a reasonable price thereof. So, there is still exemption to incapacity. As a general rule, contracts made by minors or other incapacitated persons are voidable. However, if an incapacitated person acquires necessaries without help or approval of a guardian or a parent, they are still liable to pay for those. Sale by minors. The courts have laid down the rule that the sale of real estate affected by minors who have already passed the ages of puberty and adolescents are now in the adult age, when they pretended to have already reached their majority while in fact they have not, as valid, and they cannot be permitted afterwards to excuse themselves from compliance with the obligations assumed by them or to seek their annulment. So, if a minor acts like an adult and lies about their age to sell property, they cannot later conceal the sale just because they were underage, as the law treats the sale as valid. We are now in the principle of estoppel. So, the principle of estoppel precludes a party from denying a fact, like their legal capacity, if such denial would result in injustice to another who relied on that misrepresentation. This principle acts as a limitation on the general rule that contracts with minors are voidable, reinforcing fairness and good faith in civil transaction. So, the principle of estoppel stops someone like a minor from denying their legal capacity when they misled someone, and that person relied on the lie in good faith. This principle makes sure fairness and trust are upheld in every civil transactions.
Good day, everyone. I am AC Divina, the reporter in this article, and proceeding to tackle Article 1490 of the Civil Code on how crucial one important aspect regarding property is the law in the Philippines and how it relies on relations between spouses. This prohibition that husband and wives cannot sell their property to each other. Especially, this prohibition is primarily based on foundational beliefs that the law's desire to protect the marriage and preventing conflicts of interest. So, we can continue to discuss Article 1490, a direct sale between spouses during the marriage of the couple that should be taken as void ab initio, which is from the beginning of the agreement, meaning it's not enforceable and causes fraud or undue once it was initially valid until that point. Those transactions are not even going to happen in the law. This prohibition explicitly corresponding to other void contracts in Article 1490 can even be declared void by the law, and the relationship of the husband and wife should allow their spouses to sell the property to one another to one various issues. The wife risks that one spouse, the husband persuades his wife to sell property under unfavorable terms that the law relies to protect the vulnerable spouse in such situations. While avoidance of this prohibition also serves as a spouse needs legal restrictions between the husband and wife despite of considering the law, it doesn't forbid between spouses. Also, it moderates the acceptance of giving gifts to each other while having occasions. But it could allow for the processes involved in transferring property ownership with implications of donations. It allows sales to avoid conflict of interest within the marriage, specifically if management gets concerned or leads to an ownership that maintains a clearer separation and avoids potential disagreements arising from such transactions. Thus, dealing with the spouses is supposed to efficiently transfer property that includes their matters related to other legal obligations. In this situation, marriage settlements are known as antenuptial contracts, which refer to something that occurs before the marriage, especially in a legal agreement. It also defines their financial and property rights during marriage. Additionally, if an agreement starts to be undertaken before the marriage on property relations of the ensuing spouses, the contract stipulates certain sales or transferring of their property. Moreover, it can affect the after marriage should the agreements be even earned within the time when the couple gets into marriage, and would rather have a balanced consideration of their future property arrangements. Furthermore, judicial separation of the property that the court has issued an order. Specifically, in some circumstances where the court orders a separation of the spouses, while judicial separation is in place, more prohibition of sales between spouses may no longer be held as strongly as recently in legally distinct. Inability. Inability is the idea of a legal separation agreement of a spouse after the marriage. This was an agreement that includes the provision for the sale of certain properties between them and might be considered it was reasonable for knowing each prohibition that causes more situations towards between the spouses, especially if it when is the judicial approval granted for their distinct finance. Lastly, this is the legal separation agreement in that between husband and wife could get authorization to sell or buy to each other without any provisions or void being included. The specific can-lend prohibitions under Article 1490 are no longer present.
Good day, my name is Daron Lavado and I will be discussing the Article 1491 of the Civil Code of the Philippines. The Article 1491 is all about the incapacity by reason of relation to property regarding contract of sales. So let's start. Article 1491 states that Article 1491 states that the following persons cannot acquire by purchase, even at a public or judicial auction, either in person or through the mediation of another. First, the guardian cannot acquire the property of the person or persons who may be under his guardianship. So for guardians, the relationship is considered so intimate and the influence is considered so great that any transaction that may transpire between the guardian and his ward is considered presumptively fraudulent. For example, A is the guardian of B. So therefore, A cannot buy any property of B as a minor, and this lasts until until A is still performing his duties and responsibilities as a guardian, until the property is still under his control, and until the account has not been settled yet. Next, prohibition agents. The agents cannot buy the principal's property because they are considered one judicial person. So let's say A has an agent B who he authorized to sell his house. Now, B cannot buy the house that was entrusted to him by A because they are one judicial person under the law. However, this only applies to properties that was authorized for B to manage. Let's say A has another agent C and he authorized agent C to sell his car. Now B can buy that car because it is not related to the agency between him and A. So it only applies only to properties being entrusted to you as an agent by your principal. And however, there's also another exception. The principal can provide his consent to allow sale between him and his agent. So let's say B really wanted to buy the house that A authorized him to sell. As long as A gave his consent to B, B can purchase that house. So basically, consent takes away this prohibition of Article 1491. Next, executors and administrators cannot buy the property of their estate that they are managing. Executors and administrators are people managing the properties, hereditary rights of an individual who passed away or is deceased. So basically, they are not allowed because of they are not allowed to purchase the properties that they are managing because it will be considered advantageous to them because they already know all about those properties. Their duty is to distribute the properties to the heirs, also to pay the liabilities or debts of the deceased party with those assets or properties that he collected from the deceased party. So this only applies to properties. So let's say he purchased, let's say A is an executor of B and he purchased the hereditary rights. That's completely fine because it only allows to it only applies to properties and not hereditary rights. Next, public officials and employees cannot purchase by sale, cannot acquire by purchase the properties of government and its subsidiary or any government corporation, as long as those properties were entrusted to them for them to manage. Let's say for example, the Laguna governor was entrusted to manage the property of that said province. Now, he cannot buy the said properties because it was entrusted to him. But let's say a school superintendent, which is not related at all in managing properties, but he is a public official, can still buy those government properties because it was not entrusted to him for him to manage those properties by the government. Now, let's go to number 5. Judicial officers, employees, and lawyers cannot purchase the property under litigation. Let's say, for example, lawyer A has a client farmer, which is B, and B wants to pay A with a parcel of land that is under litigation on that said case. Let's say they're claiming ownership on that said land through court action. So the lawyer A cannot accept that property as payment because it is still under litigation. This also applies to judicial officers. Let's say judges, they cannot purchase the land that is being litigated, especially if it is his own case, because it will instigate some fraudulent activity because he's the one handling the case and he wants to purchase that said property that is under litigation. So let's go to number 6. Other cases, especially disqualified by law. First example, we have alien who cannot purchase a land, an agricultural land in the Philippines. So the aliens or non-Filipino citizens cannot purchase an agricultural land here in our country. But let's say they sold a land to a Filipino, the sale becomes valid. So it is not void anymore because the possession of the land is now on a Filipino citizen. Next example is an unpaid seller who has a lien on goods they cannot buy those goods when they are resold. Lien is a right to hold the goods or the property for a set amount of time until someone pays their debt. So let's say for example that someone already paid their debt or his debt. The seller that is in possession of the lien or the goods on lien cannot repurchase those. Lastly, officers or deputies conducting execution sales cannot buy or have any interest in those sales. Execution sales, let's say for example, the court ordered that this person sells his property in order to pay his liability or his obligation. The executor, I mean the yes, the executor, the officer managing that sale of properties, and also his deputies cannot take part on the sale. Um, and let's talk about the effect of sale in violation of these prohibitions. So with respect to number 1, 2, and 3, the sale only becomes voidable. So meaning it can be annulled by court action, and it's valid until annulled. The reason why is because it only involves private interest. So if you may notice, 1, 2, and 3 only refers to private people, guardian and his ward, an agent and his principal, and an executor or administrator, and the owner of the estate. So it only talks about private interests and properties. Now, for items 4 to 6, which is public officials and employees, and then judicial officers, lawyers, and employees. These already involves public interest. This is built on public policy. So, not only is it the interest of the person with the said property, it is a public interest already. So, the sale will become null and void this time, and not voidable. So any sale that prohibits these items will become as though they didn't exist. And yes, those are the important topics to remember on Article 1491, which is about the incapacity or prohibitions by reason of relation to property. Now let's go to 1492 and listen to the next presenter.
Good day everyone. Today I'll be discussing about the Article 1492 of the Civil Code of the Philippines, which is capacity to buy and sell. So 1492. So this article pertains about the prohibitions in the preceding articles, which is Article 1491 and 1490. So these articles discusses about the prohibitions, which it, specifically on the sales by virtue of legal redemption, compromises, and renunciations. So prohibition extends to the sales in legal redemption. So a key point here are the sales, the compromises, and the renunciations. So these are the coverage of what is being explained in 1492. So in Article 1490 and Article 1491, this explains the disqualified persons. Certain individuals are prohibited from buying or leasing specific properties due to their relationship or position. So the idea here is that certain individuals are restricted from acquiring or leasing specific properties due to potential conflicts, the interest or unfair advantages. Not only those regular sales, but also those specific situations like legal redemptions, compromises, and the renunciations again. So legal redemption is when someone buys back property which was sold. Compromises are those settling disputes. And renunciation is giving up the claim or right to a specific property that is bought in the process. So by extending these prohibitions into law, the law aims to maintain fairness and prevent potential abuses in these various transactions. So, for example, imagine a judge who is not allowed to buy a property that is being sold in a case they are presiding over. So this is because it could create a conflict of interest. The law extends this idea to someone settling a dispute or giving up a right. So certain people are prohibited from specific properties to maintain fairness and prevent some unfair advantages. So I'm gonna explain more examples to further explain Article 91 and Article 90, as well as Article 92. So first example is legal redemption. So legal redemption. So imagine Anna sold her agricultural land to Ben. So under the law, Anna's brother Carlo has the right of legal redemption which buys back the property, has legal redemption, meaning he can buy it back from a certain period of time. However, Carlo is the guardian of Ben. Ben, who is still a minor, let's say like 12 years old. So the application of the Article 1492 to this is because Carlo, as Ben's guardian, who is still a minor, is prohibited from buying Ben's property directly under Article 1491. So this prohibition also extends to Carlo exercising his right of legal redemption. So therefore, he cannot use his right of redemption to acquire Ben's land. So example number 2. This would be the compromise agreement. So here, as stated earlier, compromise agreements are settling disputes. So for example, the scenario is a lawsuit is ongoing between Elena and David regarding ownership of the building. So they decide to enter into a compromise agreement to settle the case. So as part of the compromise, Elena agrees to sell her share of the building. But, however, David is a judge within the city where the building is. So, under Article 1491 rather, prohibits judges from buying property within their jurisdiction. So, this prohibition applies even though the sale is happening as part of the compromise. So therefore, David, which is a judge, cannot buy Elena's share of the building through their compromise. So Let's go to example number 3. So example number 3 is a renunciation right. So renunciation of right is giving up claim or right. So the scenario is Fiona, Greg's friend, owes significant amount of money. So Greg decides to renounce his right to collect the debt. So to further explain that, Greg said to Fiona that he gives up on like collecting the debt from her. So the application of Article 1492 states that even though Greg is renouncing his right, he cannot subsequently buy Fiona's house because as part of the renunciation, Greg also has a mortgage on Fiona's house as a security for the loan. The loan that Fiona asked from Greg. So if he falls under any of the prohibitions in Article 1490 or in 1491, for instance, if Greg was Fiona's agent for the sale of the house before the debt was incurred, he would still be prohibited from buying it even after renouncing the debt and the mortgage. So, last example. This one is gonna be this one is going to be part of the lease agreement. So in this scenario, let's say Hazel is an administrator of an estate belonging to her deceased father. So the estate includes several apartment units and some other buildings and facilities. Ingrid, who is Hazel's minor child, wants to lease one of these apartment units. So the application of Article 1492 to this scenario is, since Hazel, as the administrator, cannot sell the estate's property to her minor child because under the Article 1491, this incapacity also extends to leasing. So Ingrid cannot enter into a lease agreement for the apartment unit belonging to her father's estate. So, to sum up, Article 1492 is like a summation of Article 1419 and 1491. But the only difference is it includes the sales by virtue, compromises, and the renunciations, as well as legal redemptions. So I hope everyone learned something from Article 1492, and I would like to call up on the next presenter.
Good day everyone, I'm excited to welcome you to today's discussion. I will be explaining the chapter 3, which is Article 1493. This article dives into what happens when the item sold has been lost, which scenario that can significantly impact the rights of both parties involved, So right now, let's explore this topic together. So Article 1493 outlines two key situations regarding the loss of a sold item. Let's start with the entire loss at time of sale. So in this part, if the object disappears completely at the moment the contract is perfected or completed, so the contract becomes null and void. The second one is the partial loss. If only part of the item is lost, the buyer faces a couple of options, which are to withdraw from the contract or demand the remaining portion and pay a fare for what is left. So, to further discuss, let's break it down with a couple of hypothetical situations. Are you ready? Because understanding the timing of loss is critical. Why? Because there's a big difference between losses incurred before and after the contract has been completed. Let's say, for example, when it comes to entire loss, in cases where the object is entirely missing, the contract is rendered void. How? So let's imagine that the person A sells a car to person B, but unknown to both of them, the car had already been damaged or destroyed, in which we have no valid contract has been incurred or completed. So person A takes the loss while person B walks away with free of any obligations. But on the other hand, when it comes to partial loss, the buyer has choices in this scenario. So using the same scenario, if person A sells a car that has a damage, let's say on the front bumper, and person B is aware of this condition, person B can choose to either withdraw from the deal or accept the car while paying a price that reflects its damaged state. So about this matter, since person B has an option, so he can choose either any of those two. So in conclusion, in a summary of Article 49.3 is a guide that clarifies how loss affects sales contracts. So always keep the condition of the object in mind during the negotiation stage, because it ensure a clear understanding of each parties, and also to know the rights and obligations of both. And grasping this principle can help navigate contracts more smoothly and reduce potential disputes down the line. And it also helps on the aftermarket sales. So everyone, thank you so much for joining me today as we discuss the articles or further about 1493. And if you have any questions or you would like more examples to deepen into understanding, don't hesitate to reach out.
So now we have reached the final part of our group report. I will discussing you the Article 1494, which is the continuation of the previous articles. All of these provisions from Article 1492 to Article 1494 are closely related to each other because they deal with the risk and effects of losses, damages, or deterioration of specific goods in a contract of sale. So let's move on and understand what Article 1494 is all about. So let's read first the provision itself, where the parties purport a sale of specific good and the good without the knowledge of the seller have been perished or have wholly or in material part of deteriorated in quality to be substantially changed in character. So the seller may have an option to treat the sale first as voided, or second as valid on an existing good, or in much thereof as not deteriorated as the binding to the buyer to pay the agreed price for the goods with the ownership will pass if the sale was still divisible. This article talks about a sale of specific goods, meaning a clearly identified and individualized item like a specific car, a particular piece of a furniture, or a set of unique paintings. These goods are not replaceable by another good or the same kind, but because they are unique. Article 1494 applies when, before the goods will deliver to the buyer, they get damaged, they get lost or deteriorated, or even get destroyed without the knowledge also of the seller. Maybe the seller put the item in the storage and didn't realize that something happens on it, like a fire got burned or flooding or spoilage. Now, when this happens, the buyer has a right to choose how to proceed, since the item is no longer in a good condition as what they agreed to purchase. So what are the buyer's options? First, option 1 is to treat the sale as avoided. This means the buyer can cancel the entire contract. This is especially reasonable if the goods are completely destroyed or if the damage is so bad that the item has lost its value or its function. So like if you're still going to, me as I am going to still continue, if I am the buyer, if I will continue to buy it, it's like I'm going to buy a collectible item that has no worthless. So it's so unfair for me if the seller will force me to still pay the goods even though it's already not in a good condition as we agreed before to purchase it. Second option is the buyer can treat the sale as valid, but only the part or the pieces that remain in a good condition if the sale is still indivisible. In this case, the buyer will only pay for the undamageable part. That is helpful. It is helpful when the part of the goods are still usable and valuable. So again, the power is given to the buyer. It is their right to decide what to be depending on the condition of the goods. Let's take in a practical example. Suppose you brought a set of 10 antique glasses of vases from a seller. These vases are fragile and valuable, and the sale for it is for entire set, not for just piece. Because before they reach on you, 3 of the vases got broke due to an accident in the storage. So even though the seller didn't know that it's happened to the vases, when you find out, when it's the vases reach on you, you find out that some of them got broke. Then based on the Article 1494, you can have a 2 choices. First choice that you can have is you can say that you don't want anymore to deal with the vases because it's already broken, because you paid for full for the entire set. So you pay not for the undamageable set of antique vases. So and also you are not expecting that you will receive unbroken vases. So this is a treating the sale as avoided. Second option that you can have is you can accept only the 7 of the over 10, because 7 of them are still in a good condition and still intact, and you can only pay for only the 7 vases because among of the 10, 3 get broken, then only 7 still in a good condition. Only of them you can only pay for it. This is treating the sale as valid only in part, assuming that the contract is allowing for it. It is fair rule to consider both the buyer's right and the fact of the seller once aware of the loss. So why Article 1494 is important? First, it's promote fairness in sales transaction. Buyers shouldn't be forced to pay full price for damaged or deteriorated items. This law protects them from the situation. Second, It's recognized that the sellers, even they don't have fault whatever happened to the product or to the goods, especially if the loss or the damage happened without their knowledge also. This law or the law doesn't push the seller to punish them. It simplifies put the decision in the hand of the buyer. Lastly, it reminds us the importance of a clear agreement in a contract of sales. Like whatever the sale is divisible or not, that can be a big difference from problems like this arise. Let's wrap up our group reports. We hope we have able to present this article clearly and meaningfully. Thank you for your time, and if you have any question or any clarification, we will happy to answer them. Thank you.